right? Okay, privileged communication. Privileged communication is communication you had between doctor and the client, with patient. Privileged communication also happen when you give a statement in camera, in court, in hiding, all right, in covert. Privileged communication is when politicians talk during the a politician debate during the parliamentary session. Jangan takut, jangan tak tahu, Malaysia parliamentary session is air. All right, okay. Everybody can see it. All right. Okay, so any conversation transpired in that day one, all right, it is called privileged communication. So you can't use it. Any communication used by our duta, all right, in speaking on behalf of their circumstances, that will also be considered as private communication, even though it is telecast in the YouTube. So you cannot abuse it. Yeah. All right. Okay. Right. For the evidence to be submitted to court, the evidence must be related to the questions of law. But when you gather all that is related to the questions of facts, kan? Weight of evidence. Right. Evidence that doesn't have to go through many stages are considered as good good weight evidence. Tapi evidence that have passed through many hands, all right, changes here and there, those evidence are usually rejected in court. All right, but if the court wanted to accept it, that would be as good as well. All right, okay. Apa lagi ni? Weight of the evidence, classification of evidence. Evidence is classified into documentary evidence. We know that. Oral evidence, hearsay evidence, circumstantial evidence, real evidence, and digital evidence. Digital evidence, we know, all right, anything that is in computer or using the gadgets that pass the test of being a computer, all right, those are the real evidence. Digital evidence. Real evidence are the kertas itself, the barang-barang itself. Circumstantial evidence is always located to the event location. Right? Okay, circumstantial evidence. I cannot be the one who signed the letter yesterday because yesterday I was in hospital. That is circumstantial circumstances. Circumstances, one event to another event. Direct evidence. Direct evidence means I see and I am now the one who is the witness and consider what I see as evidence. Hearsay, dia melalui orang. Alright, okay. At one time, if it's in ship, the ship conversation that caused the collision, the ship negligence that caused the negligence, alright, all are being watched by the GPRS in the sky. Alright, the ship is identified by the radar number. All right, so that report, print out of the GPS, all right, in the sky, you can print out the report. That report is called hearsay, but it's not direct. But if I am at the beach and I saw the collision between two, all right, and that is direct evidence, right? Or direct evidence is the one, right? He signed it. Look, he signed it. That is direct evidence, right? I don't have to explain further on direct evidence. Oral evidence, whatever is being said is oral evidence. Sometimes if you tape, all right, and the tape passes from one to another, that is also hearsay evidence. Oral evidence is your voice. Sometimes people are recording certain things. That record, if it's only direct, tak payah masuk any other machine to have it able to be audible, all right, therefore it is oral evidence. Documentary evidence, all the paper, all the items is documentary evidence. All right, okay, next one. it's looking into section 3, documentary evidence. Section 3 says all document produced for the inspection of the court. Apa dia documentary evidence? All book, records, paper, or including analysis of the data and the data itself. Tahu beza analysis of the data? That is in the graph, that is in the pie chart, okay, right? What is a document evidence? Section 3 kata document evidence ada two types, primary evidence and secondary evidence. Any matter expressed or described upon any substance by means of letter, figure, mark, gambar, they are all considered as document. There are two types of document, primary document and secondary document. All right, okay, then every time when they talk about document on your act, in your act itself, on that face of section 3, buat cross kata, cross refer to section 62. In section 62, the document are the one document that later when you submit to the court will do the inspection, right? And all right, primary evidence or primary data is the evidence that is favorable by the court. Right? There are several discussion in court when it comes to crime. They would prefer the primary data instead of secondary evidence. Secondary data. All right. Best evidence rules is that. All right, best evidence rule is the document must be document is the type of evidence that is tendered to the court. That is the best. But if you can't find the document, but you can find a person who heard someone read the document, that person is also considered as evidence. All right, secondary evidence, that one is talked in, that one is discussed in section 63. All right, it is a copy of the original document. Kadang-kadang kita panggil copy, sometimes we call it as photostat document. All right. When we talk about copies, it doesn't have to be going through the machine. All right. Sometimes you copy in the old ways. We take this paper, transparent paper, we put it on the top, and then you make some movement with a pencil. You scratch at the back, you get the same document. Right, on the paper, or sometimes you snapped it. That is secondary evidence. Yeah, right. Sometimes you take the plastic, soft plastic, and you emboss the writing into it. That is secondary evidence. Right. Okay. Secondary evidence is permissible, admissible. Right, provided that the primary evidence is not available. Usually when you tender in secondary evidence, all right, what will happen? It will be rebutted. It will be sometimes objected because the primary evidence are still around. Yeah, all right, okay. Next one, oral evidence. What are all statement made before the court by witness which the court permits or requires? Dia dalam tiga bentuk. A testimony, that is what you are going to say. Hearsay is something that you hear someone say it, or opinion. Selalunya the oral evidence in opinion because you were an outsiders, but you were related to, but you have no connection. Katalah you rumah tingkat atas, you see everything but you don't hear anything, but in your opinion there were an argument. You see them argue because the way they are pushing each other in the middle of the lobby, and you saw that one. Right? Okay, that is oral evidence. A statement made orally or in a document by someone who is not a witness, then you are making a hearsay evidence, right? Okay, in the case of Subramaniam, all right, the evidence is hearsay and therefore it is not admissible. Right? Okay, if it object is to establish the truth of what is contained in the statement. Kalau you kata you want to establish the truth, then that hearsay is not allowed. But if you say you simply just want to establish that the stone exists, all right, then hearsay evidence will be acceptable. Right? That's the ruling stated by the court in Subramania. All right, direct evidence. Direct evidence is discussed in section 60. All right, facts perceived by a witness with his own sense. Dia dengar, dia nampak. All right, okay. Now these are also known as original evidence ataupun direct evidence. All right, testimony. Testimony, pengakuan. Dia waktu tu dia kata, ya saya mengaku sayalah yang telah menikam sebanyak 1 kali dan tikaman tu terlepas, hanya kena pada tangan. Testimony. You make that pengakuan, you do the act, alright. So pengakuan you tu is considered as direct evidence. That means you do have the intention to hurt, but you are not the one who killed. That would be deduced by those people who received the evidence or by the other defendant. All right, direct evidence. Usually when you have a direct evidence, all right, in Malaysia, most of the time the direct evidence has been fabricated. Maknanya telah ditokok tambah. Right, okay. Now sometimes direct evidence, you have a different perspective. You see those two people were pushing each other, you thought they were arguing, but actually they were training. Football people, when they train, they push each other, right? So if they do the same, not in the costume of training, tapi somewhere else, it looks from above, from outside, from further away, it looks as if they were fighting. Sometimes witness make a mistake with direct evidence, or sometimes witness may lie, deny, no, I'm not there. No, that one is not the document. No, I don't see anything. Right, something like that. All right. All the direct evidence usually under the scrutiny or under the cross questions by the other party, it will fall. All right, sebab tu they would prefer documentary evidence. Yeah. All right, circumstantial evidence, these are inference. The fact that, all right, she was holding the knife and there was a dead body there, so that means she must be the murderer. Kalau when it comes to accounting pula, all right, the fact that the money was in her seat, right? Okay, when we were chasing the guy who stole money from the bank, all right, and then we found that the whole bundle of money is on her seat, right? Could she be, right? Circumstantial evidence show that by inference, the one who's supposed to sit there is the thief, right? Okay, but that inference can always be easily rebutted. Maybe macam-macam lagi. But this is what I was saying. The circumstantial evidence is deduced through inference. You see the money there, you must be the guilty one who stole it. For example, you see the money in my car, all right, you think I'm the one that robbed the bank because the bank was just being robbed. Right, okay. Now real evidence, we talk about real evidence. Real evidence also known as physical evidence. Drug is real evidence, money is real evidence, blood is real evidence, body is real evidence, right? Okay. Now this real evidence sometimes is necessary to connect the real evidence and the perpetrator or the criminals. All right, digital evidence, when you use a medium to disperse information or communication, that medium is, if the evidence is through that medium, it is known as digital evidence. All right, okay, right. For presentation of this, you can see in slide number 34, what is evidence under section 3A? All right, it is oral and then it is documentary. Facts in section 3 talks about external and internal division. There are so many ways of presenting evidence to you. All right, okay. Illustration in section 3 talks about arrangement and location of things. Right, that is a fact. Things seen or heard, that is a fact. Reputation is a facts. Things said is a facts. Right? Kenapa you penting sangat nak tahu yang mana facts, yang mana law? Alright, because those facts, if collected on the right situation, they are the evidence. Right? Okay. Now, what are facts in issue? Facts in issue is facts that is in dispute. Right? I say the amount of car is 17,000. You say the amount of car was agreed last night at 15,000. So what is the facts in issue? The amount of the car. Right? Matter asserted or denied. Right? Criminal cases, yang penting sekali, facts in issue is the charge. Therefore, you tulis the charge whether there is theft in this case between Rohani and Rohana, for example. All right. Party making allegation, that is the prosecution, must prove in order to succeed. You must prove facts in issue. So the facts in issue is that Rohani is the one who signed the check addressed to herself, a check from the company, right? So what is the prosecution try to do? The prosecution will say that, all right, whatever the reason is, she draw that check to herself. Right? They can have that gambar, they can have that witness, all right? Therefore, they are entertaining the facts in issue, right? Okay, next one. What are facts in issue? Accused committed the offense. All right, accused has necessary background. Accused has a defense. Those are issues that they can rebut. Any matter that they rebut the accusation or the suspension or the recommendation of the crime, that those are the situation what are considered as facts in issue. All right, okay, relevant. Evidence only relevant if it's go to be acceptable by the court. But the court, besides the relevancy, talk about the admissibility. Right? When it is being admissible, when a law does not want to admit the evidence. We have discussed that. All right. Okay. Have you seen this slide in the half an hour tadi? Nobody wants to say anything. Everybody is tired already. Okay. All right. Identification. If you want to identify a person, that one identification is a direct evidence. All right. What can you identify? The thumbprint, the face, the photo, the blood. Those are all related to identification. In law, identification is so important that you are talking and directing to the correct person. Otherwise, it would be unfair for the person to go to the trial when he is not the one who's supposed to be the offender. All right. Okay. Any question you want to ask? Okay, Hamza. Kalau no, all right, then let me just end the lecture here today. All right. Okay, I'm saving the apa tu benda. We are going to repeat law of evidence and criminal procedure, and then we are going to, lepas criminal procedure, we are going to look into punishment and the criminal justice. All right, okay. Again, I will look into the evidence in my next class when everybody, well, anyway, you are around anyway. Again, in my next class, we are going to repeat law of evidence. All right, further powers to allow the evidence to be admissible in court. And then we will look into criminal procedure. Criminal procedure here is looking into the justice system. Yeah, all right. But when we talk about justice system, we were talking about punishment, right? How it's going to be effective, or what would be the best recommendation that you want to recommend as punishment to the crime that you have already detected and able to recommend it for prosecution. Okay, all right. Now sampai kat sini, right? If you have no questions, I am going to pause. To cancel, to stop.